Everyone. Good afternoon to all the participants. My name is Farah Habibi from ILMS FHUI External Affairs Division. And today I'll be the Master of Ceremony in the first installment of the ILMS FHUI webinar series, What You Don't Learn About ADR at University. So today we'll be joined by our moderator, Dioputra Ilham Oepangat, ACIArb, and our guest speaker, Dr. Harald Sippel, MBA, FCIArb. So Dr. Sippel's presentation will be for 90 minutes, followed by a Q&A session for 30 minutes. So throughout the webinar, participants can ask questions in the comments. Selected questions and comments will be addressed either throughout the presentation or in the dedicated Q&A session. So please enter your questions and answers in the chat box within the Zoom chat box. So prior to handing off to Fadira Mediana, the president of the International Law Moot Court Society at FHUI, I would like to remind the participants today of a few housekeeping rules for today's webinar. So firstly, participants should rename their Zoom display name to their institution's acronyms followed by their name. Furthermore, participants should have their video off at all times unless instructed otherwise by myself or the moderator. Participants should also have their microphones muted at all times unless specifically instructed by the moderator or the committee. Participants can also ask questions, as I've mentioned previously, and comment on the speaker's presentation through the Zoom chat box by using the letter Q for question and C for comment. So furthermore, we'd also like to remind participants today that we will be giving out certificates of participation. However, this will require a verification of attendance. So please turn on your cameras when instructed by the committee towards the end of the webinar. Should you require any assistance throughout the webinar, please contact our committee, either committee 1, 2, 3, or 4 via the Zoom chat. And with this, I'd like to hand over to Fadira.
Thank you, Farah. Good afternoon, everyone. My name is Fadira Mediana, and I am the president of International Law Moot Court Society of the Faculty of Law of Universitas Indonesia. I hope that everyone stays safe and healthy during this pandemic. First, I would like to thank Mr. Harold Sipple and the Bali International Arbitration and Mediation Center for their crucial role in making this webinar happen. Second, I would also like to thank and welcome the students and international law societies of Universitas Gadjah Mada, Universitas Airlangga, Universitas Pajajaran, Universitas Katolik Parahyangan, and Universitas Prasetya Mulia for their partnership with us. The International Law Moot Court Society is excited to have you all here today with us, and I hope we can have a fruitful discussion today. Farah, I'll give the floor back to you.
Thank you so much, Fadira, for your opening remarks. So I'm sure the participants are already eager to start the discussion. So please welcome our moderator today, Ilham. The floor is yours.
All right. Thank you, Fadira, and thank you, Farah, for the introductions. I wish you all a very good afternoon. My name is Dioputra Ilham Oepangat, and I will be your moderator for today's session, What You Don't Learn About Alternative Dispute Resolution in College. I'm an associate with KarimSyah Law Firm. I practice mostly in dispute resolution, and I also practice in very niche parts of the law, medical malpractice, insurance law, and partnership law. And without further ado, I would like to introduce today's speaker, Dr. Harold Sipple. He is the academic director of the Bali International Arbitration and Mediation Center. His extensive experience in ADR includes being involved in over 2,000 adjudications, mediations, and other ADR proceedings. He has acted in several hundred arbitration proceedings as an arbitrator, counsel, and tribunal secretary, and head of legal services at an arbitral institution, as well as an in-house counsel. Dr. Sipple has also been actively working with moot court teams for over a decade. He has acted as a judge in moot court competitions more than 60 times and has lectured extensively at universities on how to succeed and moot court competitions, in addition to authoring a book titled Mooting to Win: How to Succeed in International Moot Court Competitions. Dr. Sipple is also dedicated to increasing students' awareness on alternative dispute resolution, which he hopes to achieve through speaking to and engaging with participants of this webinar. And again, I would like to remind the participants today to mute their mics and their cameras. If you have any questions, we're going to hold it in sort of a discussion style. You can type your questions in the chat box, and then I will relay it as part of the conversation with Harold. And without any further ado, I think, Harold, the floor is yours.
Thank you very much, Ilham. And thank you very much to the International Law Moot Court Society. It's my great pleasure to be here. Selamat siang. And I look forward to a very engaging discussion with you. When I say discussion, I do hope that it will not only be me speaking, but there's also going to be questions from you, so that it's a sort of more interactive session. You can probably hear from my voice that I'm not entirely healthy. So the more questions you ask, the less I have to speak, because there is some break. So please help me with my health. A preliminary remark as I'm sharing my screen. What you don't learn about ADR at university. That's the title. And to make it clear here, ADR, alternative dispute resolution, can be defined in numerous ways. The way we have defined it is for it to include arbitration. So some people, as you may be aware, do not include arbitration. They say ADR and arbitration. We use it simply as alternative dispute resolution, as in something that's different from court proceedings. So it includes arbitration, and in fact, most of what I'm going to discuss today is about arbitration. Now, what are we going to cover today? I will speak about a few legal concepts. I don't want to discuss those too long because those are sort of dry. Those are maybe a bit boring. There are legal concepts you need to be aware of, so I'm covering them, but I don't want to spend too much time on them. I then want to show you selected topics from practice. In particular, we will speak about drafting arbitration agreements, and we will challenge arbitrators, which is great fun, both in practice and in a training session like this. And finally, I will be sharing 4 myths and realities about international arbitration before we go to Q&A. As my second preliminary point before I really start, keep in mind that everyone has his or her own experiences. My experiences do not necessarily reflect what you have experienced, assuming you have already experienced something, or what other people have experienced. So do not accept what I'm telling you as the whole and single truth. There is definitely much more to that. I'll, from time to time, be asking Ilham also to comment, since he is already practicing in this field. And possibly his experience is quite different from what I will be telling you about. So my point here is, listen to what I say, but rest open-minded and do not accept it as the single and whole truth. The first topic I want to discuss is one of the most important topics in arbitration. It's separability. And probably you have heard about it before. Probably you are like Winnie the Pooh and you ask yourself, what is this? It's one of the most important topics of arbitration, as I said. and such fundamental topic that without it, a major part of arbitration would not work. It all starts with the agreement. And this is the agreement to arbitrate on the one hand. On the other hand, the agreement, as in a contract you make. Now, when you do not agree to arbitrate and you do not agree on anything else, you would ordinarily go to national courts, depending, typically, the courts of the place where performance takes place have jurisdiction. If there is nothing else that's being agreed, it depends on country to country. Some countries say the courts where the party which is sued has its residence or its place of business are the courts which have jurisdiction. But I'm saying it all starts with the agreement, because when you do not agree on anything else, this is what happens. So when you have a contract between A and B, and you do not specify anything, you do not say, let's go to arbitration in case of disputes, you do not specify any specific courts, there is nothing, then this would be the default rule. So in order to be able to go to arbitration, you need an agreement. The agreement can, at large, take place two different forms. The first one is called Arbitration Clause, and the second one is called Submission Agreement. Now, again, there may be different terms for this, but at large, this is how they are called. An arbitration clause would be a clause which is part of the contract. So assume that this is your one-page contract, still empty, but imagine that there is text on it. And you would ordinarily initially write, this is a contract between party A and party B, and you would then specify the scope of the contract. Let's say my favorite example, it's for the sale of mobile phones. And you would then specify the types of mobile phones and the amount of mobile phones and the price and all that. And eventually, usually at the bottom of the contract, and mind you, this is a one-page imaginary contract. It could be many pages long, but somewhere towards the end, you would usually have a clause which says jurisdiction. And this is where you would write any dispute arising out of or in connection with this agreement, blah, 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 shall go to arbitration. If you write this, then you can go to arbitration. And this is called arbitration clause. So if the agreement to arbitrate is contained in the contract itself as part of the overall agreement, then it's called an arbitration clause. I say overall agreement because in this case, the arbitration clause is just one single item of the overall contract, which has numerous articles or paragraphs. So that's the first type. This is the type we see in, at large, 95% of all cases. The other main type, and for the avoidance of doubt, there are a few more types, but I'm really speaking about the two main types to highlight the concept of separability here. The other main type is an agreement, which also says we go to arbitration, but it's an agreement which is not contained in your contract. It's not here, but imagine that it's here on the second contract. This would ordinarily be the case that you have concluded or executed this first contract. You've probably already completed part of the contract, or maybe even the entire contract, and then there is a dispute. Now, ordinarily, you would go to your contract and you would see at the bottom, what does it say? Which court or which tribunal, whatever, has jurisdiction. If you have nothing, again, the default rules apply. If something is written there, then this is the body, largely speaking, the body, which has jurisdiction. But what happens if you believe that what you agreed in your contract, maybe 5 years ago, when you entered into the contract, is not really ideal today to resolve the dispute? For instance, because 5 years ago, you did not know that arbitration exists. It wasn't a possibility for you. And today, you believe that it would be great actually to go to arbitration. So the question arises, can you now agree on something else, namely on going to arbitration? Yes or no? And obviously the question is yes, because I said that's the second type. And what you would enter into then is a submission agreement. It's the agreement that a dispute which has already arisen shall be referred to, in this case, arbitration. So again, to recap, there are two main types. The first one is part of a contract. The second one is a separate agreement. The first one says any future contract shall go to arbitration. The second one says this present contract shall go to arbitration. You could in principle also say this present contract and future contracts. There's nothing that speaks against it, but typically parties would refer an existing dispute to arbitration. Excuse me. Now, what happens when the contract is terminated? And I'm not speaking about the submission agreement. I'm speaking about this contract where, let's say, you have the arbitration clause. So you have the entire contract, and let's say one party believes it is has a right to terminate the contract because the other party is in breach. Now, the party gives the other party, let's say, the opportunity to remedy the defect, but that party doesn't do anything. So then party A writes to party B, pursuant to clause 15 of the contract, we hereby terminate it. And this contract is now terminated. And at the bottom somewhere before the signature, it says any dispute arising out of or in connection with this agreement shall be referred to arbitration. What happens? Does it mean that the arbitration agreement is also terminated because it's part of the contract, or is there something else? Well, the answer is obvious. If the arbitration agreement would be terminated together with everything else, then there would be nothing special, and I wouldn't be discussing this. But here it's quite different. Here, in this case, the arbitration agreement is not terminated because of separability. I'm finally going back to what's written on the top of the screen. Separability basically means the arbitration agreement is separability, from the main contract. So again, if you have your entire contract here and at the bottom, it says arbitration agreement, then in principle, you have contract 1 and contract 2. And contract 2 is part of contract 1, but at the same time, it's a standalone contract because no matter what happens to the main contract, the contract or agreement to arbitrate is still as it is. And it remains valid even if the main contract is terminated, or if it was found to be invalid, illegal, etc. This is the concept of separability. I said initially, and this is my last comment before I'll see if Ilham has anything to add or there are any questions, which again, you are most welcome to ask at any point in time. I mentioned at the outset that this is super important and that without it, arbitration would not work. Why is that? Well, think about it this way. If you are, let's go back to my mobile phones example. Let's say you are buying the mobile phones to you. You are a company which sells mobile phones and you order 100,000. So it's quite a big contract. But I am a crook, you know, I do illegal things. That's what I do. And I send you the shipping documents for 100,000 mobile phones. And you pay all the money because I've shipped the mobile phones. But in half of the boxes, you don't find mobile phones, you just find bricks because I'm a crook. So now I've only sent you 50,000 mobile phones and the rest is bricks. Now, if you wanted to go to arbitration against me, you know, for not having delivered the mobile phones, let's assume you write to me and I say, no, everything is okay, and so on and so forth. And let's say I were trying to be really smart. So you write to me, if you don't pay by, you know, next Sunday, we will go to arbitration. And I write back to you, further to your email, I have lost all trust in you. I hereby terminate our contract. So I can basically rip it in two pieces, right? But so if that were possible, if I could terminate the contract this way, and I could avoid arbitration because I've terminated the arbitration agreement, then you would likely have to go to the courts of my country, which is going to be much harder than going to arbitration. But you must keep in mind that this small part at the end of the contract, it's still there. Even if I have validly terminated the contract, it is still valid because it's separate from the contract. So the tactics to terminate a contract in order to avoid arbitration is not a tactics, it's just stupidity. Because only someone who doesn't know about separability would do that. I think by exemplifying, you know, by ripping the contract into pieces and then even showing you what still remains, this becomes very clear. And with that, I'm now asking Ilham, I don't know if you want to add anything. Also, please do tell me if you believe I should highlight a certain concept better. And yeah, whatever. Yeah.
Thanks, Harold. But I think it's very interesting that you started off with separability, because I think this is a very important point to discuss, especially in Indonesia, because once we get out of college, separability is not that emphasized or is not that much talked about. There are a lot of practitioners who say, oh, does separability even exist under Indonesian law? And the answer to that question actually is yes. By virtue of the Indonesian arbitration law, Undang-Undang 30 year 1999, it is stated in Article 10H that the invalidation of the main agreement does not invalidate the arbitration agreement, which is supposed to be logic. But yeah, in Indonesia, it's something that we don't really actually discuss about. So I think it's just to add on in the Indonesian context of separability. And I would also like to remind the participants, if you have any questions, because we're holding this in a sort of discussion style, just shoot your question right here. And again, we're not lecturers like at university. There are no right or wrong questions. You can ask anything you want with regards to this topic. Also arbitration clause and submission agreements are also recognized under Indonesian law. Arbitration clause is simply perjanjian arbitrase, and submission agreement is also called akta van dading. So what's the difference between the two? Under Indonesian law, an arbitration clause is made prior to a dispute. That's how the scholars distinguish it. And the submission agreement is made after or post when the dispute has arisen. And that was actually a really good point to start off. Thanks, Harold.
Thank you, Ilham. I think it's really great if you make the connection to Indonesia. I think that really helps everyone, including myself. I'm obviously not an expert on Indonesian arbitration law. If there are no points, no questions, let me move on. And again, I appreciate that this may be a bit boring. It's a bit dry. I'm trying my best. I'm even ripping up paper here, but some of it is as it is. I'm trying hard to make it as much fun as possible, but I can do only so much. I also would like to remind you that Lex Arbitri, the second topic I'm going to discuss, is one second. I just see we get a question. What if one of the parties terminates the arbitration agreement unilaterally?
That's the question.
Yeah. You cannot simply terminate the arbitration agreement unilaterally. I mean, it still prevails. That's that's a good point. You could say, I first wait. I'm looking for another sheet of paper. I mean, here is my ripped up contract. Already ripped it up, and here is my arbitration agreement, and I also terminated. It doesn't work. But good question. I think you got the point. Lex Arbitri. If this were an in-person lecture, I would now ask for a show of hands who has heard it before, but that's not quite possible on Zoom. But what is the Lex Arbitri? We have to go back quite a bit. We have to go back to the concept of the seat of arbitration. And I chose this topic to discuss because it's also a very, very important fundamental topic. And especially when we speak about international arbitration, and a topic that's often misunderstood. The seat of arbitration, to start with, is not like a chair. This is absolutely not what it is about. It is a legal concept only, a virtual concept, so to say, and not something physical you can touch. It will determine the procedural law of the seat of arbitration. So you would specify the seat of arbitration, usually in your arbitration clause, but not necessarily. We'll get to that later. You would, for instance, say the seat of the arbitration shall be Jakarta, Indonesia. When you say that, the procedural laws, as referring to arbitration, but please not the Code of Civil Procedure, only as refers to arbitration, of that place shall apply to the arbitration. So when you say Jakarta, Indonesia, then the ADR law of 1999 would apply. When you say the laws of Singapore, then the Singapore, if it's an International Arbitration Act would apply. When you say, when the place of arbitration is, say, Berlin in Germany, then it would be the portion of the German Code of Civil Procedure, which is about arbitration law. It's only this part, nothing more and nothing less. What's also important here is that each arbitration act has mandatory rules and it has non-mandatory rules. Now, mandatory rules are simply provisions in the Arbitration Act, or, I keep saying Arbitration Act. In Indonesia, it's a separate law. In many countries like Germany, like Austria, where I'm from, it's simply part of the Code of Civil Procedure. But forget about that differentiation. Just assume that we're speaking about one and the same thing. So when I say Arbitration Act, it would be the same as in a separate act or something that's part of the Code of Civil Procedure. But always only these rules of the Code of Civil Procedure and not the whole thing. So you probably have some, 50 rules. And out of those, some of them are mandatory and some of them are non-mandatory. Mandatory means that no matter what the parties agree, they cannot change them, and they apply no matter what. A typical example would be in most countries, it is not possible to say that after the arbitral award has been rendered, there shall not be anything you can do against the award. So in arbitration, there is no appeal, but there is setting aside. That's the typical remedy against arbitral awards. And the parties can, in most countries, not agree to say, let's also get rid of the setting aside proceedings. In some countries, like Switzerland, it is possible to even do that, although I'm not an expert on that. But in some countries, you can agree to also remove setting aside proceedings. But I'm not going there. I want you to keep in mind that there are mandatory rules and non-mandatory rules. Now, why? Oh, another thing is, I mentioned those setting aside proceedings, which is the remedy against an arbitral award, as I said. So when you get the award, you are typically happy or unhappy. Sometimes you don't quite know because it's yes or no. It's good and bad. But if you are unhappy, then very often you want to do something against the award. Just very colloquially speaking. If your client gets an award that's against your client, then very often your client will say, okay, I want to fight this. What can we do? Now, if it were proceedings in court, you would simply appeal, right? This is not possible in arbitration because arbitration by default is something that's not appealable, but you have other remedies. And the main remedy is the setting aside of the award. You can either, I'm now again picking up a sheet of paper, you can either set aside the whole award or you can set aside part of it. It's hard, or I shouldn't say it's hard. When you set aside part of it, it must be something very distinct. A very good example is, let's say this is your award and it says, it discusses like a judgment. You've probably all seen judgments in court. It discusses everything, and at the end it says party A shall pay party B $5 million. And just before that, it also explains who shall bear the costs of the proceedings. By costs of the proceedings, in particular, I mean the lawyer's fees, the fees for the arbitrators, and if it's an institutional arbitration, the fees for the arbitral institution. Who shall pay them? It depends. You can say loser pays all, you can say 50-50, you can say you look which party succeeded, and if one party won to the extent of 80%, then that party shall pay 80%, and the other party, then that party shall pay 20% because they won for 80%, so only the part they lost they shall pay for. The other party lost for 80%, so they shall pay 80%. There is ways to do it, But you could, for instance, that happens, in fact, quite often when there is only a portion of the award that is attacked, then the cost decision is the one which is being set aside. But whether you try to set aside the whole thing or just a portion of the award, it does not matter. The key point here is this is your main remedy against an arbitral award. And I say main remedy because in some countries or under some rules, you have other remedies, but in almost all countries, that's your one only remedy. Now, who would you go to set aside an arbitral award? You would go to the courts as specified in the lex arbitri. The lex arbitri would usually explain under what circumstances an award can be set aside. And it would also say which court has jurisdiction. Now, after you have determined that, you can file a brief with the court to set aside the arbitral award. And this is why the lex arbitri is important, not only during the proceedings, because the procedural law applies, but also after the proceedings, namely when one party wants to have recourse against the arbitral award. From practice, maybe, a lot of people wonder which one is more important, the substantive law, the law which provides or which governs the rights and obligations of the contract, namely when we speak about my mobile phone example, when was the purchase price due? How do you interpret the contract? What are the terms of delivery? All that, assuming it's not explicitly set forth in the contract. So that's the substantive law. The other one is the procedural law. Which one is more important? It's a very hard question. And I would say it depends. I say so because it's hard, and to any hard question, I would say it depends. But it really depends on the circumstances. I think a lot of people make the mistake of agreeing to arbitrate under a seat which is not an ideal seat because the laws of that country are not so arbitration friendly. When you do that, you can run into a lot of trouble, and it can result in a situation that you may have an arbitral award at the end of the day, but it's being set aside for no proper reason, simply because the courts of that country are not arbitration friendly. It can also mean that you run into a lot of problems in the course of the arbitration. For instance, there are some countries which say only nationals of that country may represent in international arbitration proceedings. So imagine you have your trusted lawyer, and that lawyer is an arbitration expert, but suddenly you cannot rely on that lawyer. That's not an ideal situation. You want to avoid that. So it's not really possible to say the law of the seat is more important than the law of the substance. It really depends. What you need to know still in the lex arbitri is that the parties are in principle entirely free to choose the seat of arbitration and thus the lex arbitri. And in fact, you could even choose a mixture. You could say the seat of arbitration shall be Jakarta, Indonesia, but the laws of Singapore shall apply, and here the procedural laws. This is possible. Whether that's a good thing is another question, because it usually adds a lot more complexity and also problems. But what I'm trying to point out is that just like you could agree on the substance of the contract as you wish, as long as both parties agree, you can at large also agree on the procedural rules, except for the mandatory rules at the seat. Again, you cannot deviate from the mandatory rules. This is simply not possible. That's why they are called mandatory. And I think that's been quite a bit and quite long. So I'm again handing back to Ilham.
Okay, Harold, we do have a question. What would happen if the losing party does not keep his end of the bargain according to the arbitral award? Is there any mechanism to enforce it? He said it, since it's not exactly like a decree from a national court. So
okay. See, it's unfortunate that this is not in person, because I don't know who asked the question, but whoever asked it, if you were in front of me, I would now say, so what happens if you have a court judgment and the other side doesn't pay? Can you do anything about it? In principle, you cannot do anything about it unless you again go back to court and ask the court for help. But just because one party does not fulfill the award does not make it any different to one party not fulfilling what's written in a judgment. It's one and the same thing. So there is no difference. However, one huge difference is that in arbitration, you have an international instrument which allows you to enforce arbitral awards. So wait, maybe let's go a step back, because I want to make sure we're all on the same page. So this is your judgment or your arbitral award, and it says A shall pay B $1 million. Now, what if A does not pay? What can you do? The only thing you can do is you can go to court and ask the court for help. And this applies whether it's an arbitration or a litigation. It's one and the same thing. So the court will then, that depends on each country, but at large, the court will send someone from the court to that company and will basically say, unless you pay within 14 days or maybe a month, we will start taking away your stuff. You know, to put very plainly, very colloquially and not legally. They will sell the company's property. They will sell the company's land and assets, machinery, the office equipment, etc. This is how you enforce a judgment, and you don't enforce it differently when it's a judgment or an arbitral award. In practice, it's always the same. Someone from the court will ultimately go to that company and say, I'm going to take away your stuff. The difference is that when you have a judgment from Indonesia that says, I shall, let's say I'm going back to my mobile phones, I shall pay you $1 million. But if I don't pay, then good luck going to Austria with your judgment from Indonesia. It's not worth the paper it's printed on. And that's not because it's a judgment from Indonesia. Same thing, if I have a judgment from Austria and I'm trying to enforce it in Indonesia, the Indonesian judges are not even going to look at it because they say it's an Austrian judgment, I don't care. Unless there is a treaty between Austria and Indonesia saying that Austria shall recognize Indonesian judgments and Indonesia shall recognize Austrian judgments, you cannot do anything about it. In arbitration, there is an instrument, an international treaty, which says the countries which are part of this treaty shall recognize arbitral awards and enforce them as though they were national awards. That is, awards which were made in that country. So that's the big difference.
All right. Thanks for that, Harold. If I may add, that is exactly the reason why Lex Arbitris is so important when you're advising a client where to arbitrate. For example, if we're talking about like concepts such as enforcement, it's especially in Indonesia. I wouldn't say that Indonesia is the most friendliest country when it comes to arbitration. One of the hindrances of, for example, enforcement is that the arbitrator himself has to register the award at the state court here in Jakarta, at the Jakarta Central Court. So well, what needs to happen is that the arbitrator needs to give the lawyers here another power of attorney for us to be able to register the award in order for it to be able to be enforced. This topic, lex arbitrae, it's one of the heaviest and I think one of the most important topics in international arbitration, especially when it comes to enforcement in Indonesia. And we do have another question here from Travis. What kind of enforcement obstacles have you experienced in Indonesia? Okay. What kind of obstacles can we as potential future practitioners expect to face?
I think that's a question, Ilham, which you are much more suitable to answer than I am. I can only tell you this much. I agree that Indonesia is not the most arbitration-friendly country. It's not the least one either, but things could be much better. And you mentioned one example.
Yeah.
I know someone from Australia who has practiced in Indonesia for many years. And he has told me that it's extremely hard to get an award in your favor, enforce it, and eventually get the money out of the country. I don't know if that's true. You would know much better.
That might have been very well the case. I think when it comes to enforcement here, it would take ages. I mean, I'm not going to beat around the bush. I'm just going to be very direct. Enforcement here of international arbitration awards takes very long. Secondly, there is no set of rules which would allow you to contest enforcement in Indonesia. So once you have registered an award at the Central Jakarta District Court, then you could only hope for the Central Jakarta District Court to find that actually the award is unenforceable. There is no mechanism for you to say, hey, look, the award doesn't conform with the New York Convention, yada, yada, yada. And again, there is no timeline in which the courts actually have an obligation to finish the enforcement procedure. So it would really, really take long. And I think that is one of the biggest obstacles, in addition to, I think, setting aside of the award, since most of the reasons why we can't enforce awards under the New York Conventions are also the reasons for setting aside an award under most arbitration laws. Is that Indonesia actually only has 3 reasons why an arbitration award can be set aside. And these are all criminal reasons, which to me doesn't really make sense. But again, at first they are like very filtering these reasons. And then suddenly, if you look at the elucidation of the law, it states that these reasons are among others. But it is not specified what among others mean. And that is why the spectrum is now very, very broad. You can annul an award on the basis of the extreme case would be, I'm annoyed at this award. The law doesn't prohibit it. So that is something about the lex arbitrae of Indonesia, which I think we should reform. And we have another question. I'm sorry, I skipped Brian's question, which actually came first. What procedures are necessary in the case where both parties agree to conduct mediation arbitration or arbitration mediation?
Okay, so MEDOP or ARB-MED?
Yes.
Okay, so that's quite a bit off, but I'll try to be brief. In principle, there are 2 types. Some people say MED-ARB is a process where you first have mediation and then you have arbitration, a step process. And those step clauses or multi-tier dispute resolution clauses are actually very common. The reasoning behind them is when you have a dispute, very often you are upset. Think of the last time you had a fight with your friend. I hope not a physical fight, but I think initially you didn't quite want to speak to your friend because, you know, you're upset. If someone upsets you, our reaction is sort of, you know, to be upset, right? So you don't want to speak to that person. Now, it's very easy to make a mistake when we are upset, to do something which we wouldn't ordinarily do, but we do it because we're upset. And as a result, you go to arbitration right away. You know, you're very upset, you go to arbitration. This is, of course, not you and your friend because you don't have an arbitration agreement, but think of it as a relationship between two companies. Now, if you have a contract which says when there is a dispute, first you shall negotiate for a month, then you shall try to mediate for 3 months, and only then you can go to arbitration, then very likely you will not be so upset anymore as you were initially. Maybe you're even more upset, but the initial feeling of being angry and saying, I will sue you, this is simply not going to be there. So this is why those multi-tiered dispute resolution clauses are often used in practice. Now, that's the one thing. The other thing, when we speak about ARB-MED or MED-ARB in its traditional and pure form, then you have mediation, and the mediator also acts as the arbitrator if the mediation fails. Or the other way is you start with the arbitration, and if the arbitration fails, then you go, if the arbitrator realizes that the parties could reach an agreement, then the arbitrator sort of takes off his mediator hat or her mediator hat, arbitrator hat, and puts on the mediator hat, and then mediates between the parties. So first arbitration, then mediation, but by the same arbitrator. This is MED-ARB or ARB-MED in the traditional sense. It offers a lot of advantages because the arbitrator / mediator will know about the dispute much better, will know the parties much better, and that often makes it possible to reach a settlement much more easily than when there are two different persons involved. The big problem is what you say in a mediation is something you would never say in an arbitration from time to time. Because in a mediation, you know that the mediator cannot impose anything on you. It's always you and the other side which have to agree. And, you know, there is much less risk in that sense. If you can openly speak to the mediator, then when there is no risk, you know, then so be it. But if that mediator suddenly becomes the arbitrator, the question arises whether the mediator can then, the mediator now turned arbitrator, can forget what happened during the mediation and simply rely on what the mediator has in front of herself or himself. In principle, once again, you can agree on anything as you wish, as long as it's not in violation of any mandatory rules of the law of the seat.
All right, thanks, Harold. There's another question. What would happen if the award is denied by Indonesian court? I think we could talk about courts in general first. Like, what would happen if it is denied in courts?
That's a good question. I think by denied in court, what the person asking the question means is, what if the court sets aside the award? I mentioned the New York Convention before. This is an international treaty to which I think now 163 states are members. And it says if this award was made in country A, then it can also be enforced in those 162 other countries. Excuse me. Now, one huge advantage of arbitration, especially when it's between bigger international companies, is that once you hold the award in your hand, you can go wherever you want to enforce it. As long as the company against which you enforce the award has assets in that country, you can go and enforce it there. So think about it. Let's stick to my example. I'm doing this seminar or this video now from Kuala Lumpur in Malaysia. But so let's say my company and your company have a dispute, and ultimately you get an award against my company, and you come to Malaysia, and the Malaysian courts say, this award has problems, so we're not going to enforce it. You could still go to Austria, where I also have assets. Don't tell anyone, but I do. And you could try to enforce the award there. So that's the big advantage. When it comes to the setting aside, that's a different issue. Setting aside, there are broadly speaking, two big legal concepts. The first one is, if this is my award and I set it aside, then it's gone. You know, it disappears because I've set it aside. This is the view which is predominant, and that's the view that more countries take. The other view, which is especially prominent in France, is that the arbitral award will exist irrespective of whether it has been set aside or not. So even if you have this torn award, so to say, you could still take it to a country and try to enforce it there if that country takes the view that an award which has been set aside can still be enforced. This may sound very, very strange to you, and without knowing the background, it is. Above all, it creates a problem, namely that you don't have legal certainty. In principle, you should have legal certainty. The moment you set aside an award, it's gone. This would be ideal in principle because you know what's happening. No more award, it cannot be enforced anymore. The issue is, what happens when a court sets aside the award, not because the award should have been set aside according to the law, but it was only set aside because there are other interests. And this has especially been the case in Russia, where courts have multiple times set aside awards for no apparent reason. And in this case, the courts of other countries have at times said, when it simply makes no sense, so to say, that the award was set aside, then we will still enforce it, even though it has been set aside. So when you keep that in mind, that legal certainty, which I said originally is gone, is sort of brought back to some extent, the legal certainty of arbitration, namely, when you get a proper arbitral award, it can be enforced. So you get it back in a way, but it's a very complicated issue, and this was discussed a few years ago at a conference, or at two conferences, by two very important people. One of them being Gary Bourne, the other one being Justice Menon, the Chief Justice of Singapore. And even among those two gentlemen, they took contrarian views. And this was titled The Clash of the Titans. So you can see that even the best known people in the world of arbitration have differing views from time to time.
All right, thank you, Harold. Specifically for Indonesia, what would happen if enforcement is denied is that the party who is being denied enforcement can request kasasi, to the Supreme Court. But that would be your only legal remedy from like the Lex Arbitrae perspective. Other than that, as practitioners, we would advise exactly what Harold has said before. Try to find assets in other countries where it's more arbitration friendly, and then you could enforce it there. I think there are no further questions on this topic. I think we can move forward.
Mm-hmm. I'll tell. I'm always trying to make any speech or lecture I give as practical as possible and also as fun as possible. And on your last point, Ilham, try to find assets somewhere. I have a funny story to tell, but which is not just a story, like a fairy tale. It's actually true. It's the Franz Sedlmayr case. Franz Sedlmayr is a German national who had, many years ago, a security company in Russia. At some point, Russia took away that security company. He was basically taking away his property. Now, that's usually not possible in the sense that many countries have the protection of foreign investors through investment treaties. And you can then typically go to arbitration. And this is what Franz Sedlmayr did. So he started arbitration proceedings against the country, Russia, against the state of Russia. And after a long battle, he eventually won. Now, he had this wonderful award in his hands, which said Russia shall pay him, I think it was well over $1 million, so quite a significant amount of money for a natural person. And he took that award to Russian courts. But unsurprisingly, I should say, the Russian courts did not quite agree with the award, and they all refused to enforce the award because they should have enforced it against Russia itself. So what are you going to do? How do you find assets of a country abroad? This is certainly not easy. But Franz Sedlmayr has been quite successful considering the difficulty. For instance, he found that, I don't know the details about this, but part of the Russian embassy in Sweden, in Stockholm, was not covered by state immunity. So he could convince, so to say, Swedish courts to help him there. And the courts threatened to auction off part of what was part of the Russian embassy in Stockholm. So he got some money there. There was once a Russian plane, and I don't know what exactly happened there, but he also got some money. And there was once an exhibition on outer space, and there was the suit of a cosmonaut, as it's called in Russia, not astronaut, but cosmonaut. And this suit was worth $40,000, and he was able to take it away and then sell it off. So,
wow. Great lawyers.
Right. You have to be, I mean, these are extreme examples because usually arbitration is between private companies. Of course, we have investor-state arbitration, but these are, a minimal amount of cases as compared to commercial arbitrations. But so this is a really extreme story, but sometimes you must be creative, and you will eventually succeed. Another, the final fun story about this is that Franz Sedlmayr has since founded a new company which is specialized in asset tracing. So it's a company which helps you find assets of another company all around the world. So he has made, you know, the enforcement of this award his hobby, so to say, to his profession.
That's cool. I should get his number. All right.
Okay.
Yeah.
How much time have we left, Ilham? Because I lost track.
No worries. I think we have till 2:50, but I guess
Okay.
the committee is a very nice committee, and we could probably get an extension of time of a few minutes.
Okay. No, that's great. Then let me move on. If I go back, I said I want to speak about some legal concepts. We're done with that, and I think we covered a lot more than what's on the slides. Now a few selected topics from practice. And since I said it all starts with the arbitration agreement, let's find out how we can draft international arbitration agreements. And I have good news to you. It's very simple. It is like making pizza margarita. So what do you need for pizza margarita? You need the dough, you need the tomato sauce, and you need the cheese. That's it. An arbitration agreement is as simple as that. So what are those three ingredients? And I'll rush a bit. If you have any questions, please raise them. You need the agreement to arbitrate. Now, that sounds a bit like I'm saying the same thing again. Why do you need the agreement to arbitrate when you're drafting an arbitration agreement? Agreement to arbitrate basically means here there needs to be, sorry, something is wrong with my slides. There needs to be a clear agreement in the contract that you refer disputes to arbitration. We'll look at that in a minute. You need to have the scope of the arbitration agreement. We'll also discuss that. And the finality of awards must be there. By finality of awards, I mean that there cannot be any appeal mechanism, because usually, or in principle, that's against the concept of arbitration. So these are the three ingredients. Let's look at the Uncitron model arbitration clause, so you see what I mean. For those of you who do not know what Uncitron means, it stands for United Nations Center for International Trade Law. It's part of the UN in Vienna, and they have model arbitration rules and also model arbitration laws, which countries or institutions can adopt. Now, this is what the clause says: any dispute, controversy, or claim arising out of or in connection, or relating to this contract, or the breach, termination, or invalidity thereof shall be settled by arbitration in accordance with the Uncitron arbitration rules. This is what the rules say. And you find at least hidden all three agreements in this clause. The first one is shall be settled by arbitration. That's the agreement to arbitrate, which is contained in the arbitration clause, settled by arbitration. The second one is any dispute relating to this contract or the breach, termination, or invalidity thereof. So here it clearly sets forth the scope. The scope is it shall not simply be one single dispute, it's really everything, any dispute. So this is the scope. And you may ask yourself, where do I find about the finality, the third ingredient I mentioned? Well, you find it because you would know from the rules that the award shall be final. So that's the finality. You don't really find it in the arbitration clause, but you find it indirectly because you would refer the dispute to the Uncitron arbitration rules, and they say that an award shall be final. Now, this is an arbitration agreement in the most basic form, those three ingredients. And if you know how to do it, you can make pizza margherita. Pizza margherita is great, but usually we want more. We are not satisfied if there's just the dough, the tomato sauce, and cheese. So I give you the option to make another pizza and to highlight to you how an arbitration clause typically looks like in practice. You'll also learn how to make pizza quattro formaggi, a 4-cheese pizza. This is what quattro formaggi means. You would usually identify the arbitral institution, the number of arbitrators, the place of arbitration. Sorry, my slides are not working well. And the language to be used in the arbitral proceedings. So you have 4 types of cheese, as you can see on my slides here. Now, when we look at the ICDR model clause, the ICDR is simply an arbitral institution. They have, in principle, the same language I just mentioned here. Any controversy or claim shall be administered in accordance with the rules. And sorry, here it doesn't say administered, it says determined. Determination is also indirectly saying finally settled. There you have the finality. So here you have it more clearly than in the Uncitron model clause. And then it gives the parties the option to add 3 more elements: the number of arbitrators, the place of arbitration, and the language. Now, I said 4 elements. Where is the institution? It's of course contained in the first clause saying administered by the International Center for Dispute Resolution. So this is how, and I fully appreciate I was a bit quick in the interest of time, but this is how a typical arbitration clause would look like in practice. You have the standard phrase saying usually any dispute, and it's usually all encompassing. You would usually identify the institution unless it's an ad hoc arbitration. And mostly, but of course not always, parties also identify the number of arbitrators, the place of arbitration, which is nothing but the seat of arbitration. It's the same thing. And the languages or language of the arbitration. A few words from practice on drafting arbitration agreements. As you can see from my slide, this is something I copied. I took a screenshot and then copied it. Every single arbitral institution offers a model arbitration clause, as it's called. If you are not an expert in arbitration, please do not mess with this model arbitration clause, unless you want to spend a lot of money on legal fees and you want to lose a lot of time. I have seen so many messed up arbitration clauses because the parties thought that they were very smart and they could play around with the arbitration clause, and they made all sorts of additions and they left out parts, and it just results in a big mess. Do not think that it's a good idea unless you really know very well. What you can do, of course, as you can see on the screen, is to say the number of arbitrators shall be 1, or you say shall be 3. This, of course, is totally fine. Of course, you know, wherever it's blank, you are encouraged to fill it in, or where you have a choice. But it's very problematic when you change too much of the arbitration clause and where you add elements which should not be there. In practice, parties which try to be very smart usually end up being very stupid because they lose a lot of time and pay a lot of money. A word on the arbitrators in practice. Should there be one arbitrator or shall there be three? The answer is, it depends, as with so many answers. At large, in practice, I would say the sole criterion is the amount in dispute. This is what it really is in practice. Many arbitral institutions say they also take into account other factors such as the complexity of the case, etc. But and this is only if you have not specified it. If you have specified one arbitrator, then it is one arbitrator. If you have specified three, then it's three. But if you have not specified, then the institution must make a determination. And institutions say they also take into account the complexity, but I can tell you myself that most disputes I acted in as an arbitrator were very complex, and no institution in the world would have assigned three arbitrators because typically the amount in dispute of those arbitrations was very small. And then you have the problem that very few arbitrators are willing to work for a small amount of money. And just finding three arbitrators is going to be very hard. So that's the number of arbitrators. What has happened in the last years is that a lot of people have complained about arbitration being too expensive. And as a result, several arbitration rules now say if the amount in dispute is below this amount, then there shall automatically be one sole arbitrator, and the proceedings shall be expedited. This is often highly problematic because when you have a small amount in dispute, it often means that the parties represent themselves. They don't have any lawyers. If they have lawyers, very often those lawyers are not really experienced in arbitration. And that itself makes the process more complex. And then when parties don't know how the practice of arbitration works, it also adds additional complexity. So I'm very critical of this recent trend based on my own experience. I can tell you many stories. One of them, for example, it's my favorite story. This was my first case where I acted as the chairperson of the tribunal in a very small dispute because the parties had agreed that there shall be three arbitrators. So in principle, it was good that there were three people because it was a very complex dispute. But I'm highlighting just the complexity of small amounts in dispute. One party represented itself, the respondent, and usually in the beginning of an arbitration, you agree on a procedural timetable, which basically says on this date, party A shall do this, and on this date, party B shall do this, and then party A, party B, and it goes on and forth. And we had agreed on everything for weeks, if not months. And suddenly, one party wrote to me, or to the tribunal, I should say, saying they cannot stick to the timetable, and that's all they said. Which in itself is highly unusual because you would obviously have to give a reason, and that was also made clear in orders we had given to them. But when you are not represented by a lawyer, what do you care? And the reason we were then given was that in the Netherlands, where this party was from, this date, I think it was 5th of December, but I'm not entirely sure. It's a sort of, it's not a national holiday, but it's a date where children celebrate with their parents and family, and they write poems for the family, and the family gives the children small gifts. So this was the reason why we were supposed to move the timetable month after we had agreed to it, which is a complete joke. You know, you would not see this if you have professional lawyers acting on it. In this case, you would only move a timetable for a good reason. Let's say, you know, COVID-19 is now a good reason. If the office is in lockdown and you cannot access your computer, then that's a good reason. A friend of mine was involved in an arbitration many years ago when Fukushima happened in Japan, the earthquake, and there was no power anywhere. That's also a good reason. It can be a good reason that you simply need more time, but you know, finding out month after you have agreed that it's a sort of public holiday is definitely not a good reason. So that's just a fun story to share. And I think I've again spoken way too long. Back to you, Ilham.
That's no problem, because the committee just told me you could have like an additional 30 minutes, so we'll cut it out of the question and answer time. So that's no problem. We have roughly about an hour more. We have a question from Amrul Akbar. He's asking, when there is the flawed arbitration clause or invalidated, and the dispute arises, are the parties still able to arbitrate? That's an interesting question.
Yes, because you would first need a determination from the tribunal or from the court that the clause is invalid. What the New York Convention does, which I mentioned before, is two things. The first one is enforcement, or I should say the second one is enforcement. The first one is it forces courts of the member states to acknowledge and accept arbitration agreements. So unless the court determines that the arbitration agreement is invalid, it shall refer the plaintiff, you know, of those court proceedings to arbitration. So let's put it in practice. You have, again, two parties, orange and green, and they have an arbitration clause. Green doesn't care. Green goes to the national courts and says, I believe litigation is much better. Then ordinarily, the courts of this country should say, well, yes, we hear you, but you have a valid arbitration agreement. And as a result, we do not accept this claim. You must go to arbitration. So this is what the New York Convention also does.
All right. I don't think we have any. Oh, we do have a question, another one. Could you share your thoughts on unilateral arbitration option clauses? I think this was a very controversial topic at the last year's Vismood. Like one party has the ability to arbitrate and the other party only has the ability to litigate. So what are your thoughts on that?
My thoughts are, don't mess with the arbitration clause. I don't think it's a good idea to provide such unilateral options. They are invalid in many countries, and you simply risk having to go to national courts. It's not something you want to do. The advantage you gain by having that option is never going to be outweighed, or I should say, the advantage is always outweighed by the disadvantage of the risk that something gets invalid. And when it gets invalid, then yeah, that's really not good. Yeah, I'm also generally not a fan of. I'm doing an arbitration right now the client is from a Central Asian state, and the other side is from Western Europe, and the contract says whoever starts the arbitration, the laws of that country shall be applicable to the contract. Sometimes you see the same with that shall be the seat. I'm not a fan of that because I don't quite see what it adds. It seems to me that parties saw this somewhere in the contract and they don't quite think what it means in practice, and then they just agree to it. But that's not how it should be done. It would be better not to agree on anything to that end.
I agree 100%. Like from an Indonesian perspective, I would say to a client, don't even try. I mean, we already have that much problems enough with enforcing an arbitration award, which was based on a valid arbitration agreement, and now you want to throw in a unilateral clause. I think it adds very much distress to the courts, especially in Indonesia. I think that's it for the questions. I think we could move on to the next subtopic.
I think one last comment. In many countries, the courts are really not familiar with international arbitration. It always depends what court you're dealing with. But, you know, Austria has long been an arbitration hub, even because we used to be between Western Europe and Eastern Europe in the times of the Cold War, and many West-East disputes went to Vienna. So we have a very long tradition of arbitration in Austria. If you go to courts in Vienna, they are generally rendering good decisions and they know what's happening. But if you go to the district court of, you know, somewhere else in the mountains where I grew up, they have no idea what arbitration is. And if you then mess with the clause and make everything more complicated, then yeah, you're asking for trouble. Okay, then let's move on. I now want to discuss about the challenge of arbitrators. And when it comes to the challenge of arbitrators, the key phrase is the one you see here: justifiable doubts as to the arbitrator's impartiality or independence. So what does that mean? That's a lot of new information, a lot of new concepts. Keep in mind that arbitrators may be selected by the parties. One of the huge advantages of arbitration is that you can choose your own arbitrators. And there are some people, I understand this is a quote from the old Pierre Lalif, who say arbitration is only as good as the arbitrator gets. I'm not sure if that's correct, but appointing an arbitrator is a very, very important step in the arbitration. Now, when you go to court, usually the judge is going to be independent from you, because usually there is no relation whatsoever to a judge. In arbitration, this is a bit different because the people who act as arbitrators very often have more than one single role. Now, what do I mean by that? Sometimes arbitrators also act as counsel. So they decide disputes on the one hand. On the other hand, they also act as the neutral who's determining the dispute. This adds more room for conflict. Judges can typically only be judges, and usually they cannot do anything else. It depends from country to country, but very often they are not allowed to do anything else. An arbitrator can do a lot, I mean, is allowed to do a lot more things. For instance, an arbitrator may also act on the board of directors of companies. Now, many companies have at least one lawyer on their board of directors. You know, it's nice to have a lawyer who knows about the law on the board of directors. So suddenly you're not just an arbitrator, but you're also someone who represents a party and who has sort of an interest because you're acting on the board of directors of a company. And it adds a lot more complexity. Also keep in mind that, yes, in principle, you can appoint a person of your choice, but if you could appoint just anyone without any limitations, then you would very likely appoint someone who you know will decide in your favor. If this were so, everybody would lose trust in the concept of arbitration. Because if you can appoint, say, your spouse, or your mom, your dad, your brother, your sister, then, you know, what is this? No one is going to believe that this is actually a person who will be unbiased, as we say. So unbiased means a person who is not predisposed to anyone's case. Now, imagine that you yourself are in a situation where you don't really know who you should decide for based on the law and based on the facts in front of you. But one person is a very close friend of yours. The other person is someone you don't know. Who are you going to decide for? Of course, it's your friend. It's in our nature. So in order to avoid that this happens, and in order to avoid that the whole system doesn't work because we appoint people who are basically biased, there is the concept of impartiality and independence. What you can see on the screen to the left side is a blue booklet or a screenshot thereof called the IBA Guidelines on Conflicts of Interest in International Arbitration. This is a standard book which sets forth various situations in which an arbitrator may find herself or himself in, and then says this is acceptable, it depends, and this is not acceptable. It does so by means of a traffic light system. So there are red light situation or red list situations, orange list situations, and green list situations. As you can imagine, red light means stop, orange light means it depends, green light means okay. And please don't say, I don't care about the traffic lights, because in Indonesia, it's not always as strict as this. Imagine that it were very strict, and imagine that everyone should adhere to it. No offense against Indonesian traffic. Now, how does this work in practice? I'm not going to go through everything because it would take too long, but I'd like to share a few situations with you. And unfortunately, this is not in person, so I cannot ask for a show of hands, but I'll always ask you to sort of reflect for a few moments and then think whether this, in your opinion, should be red, orange, or green. So situation one is as follows. The arbitrator and another arbitrator are lawyers in the same law firm. Now, imagine that the claimant appoints Ms. Jane from Disputes Ltd. The respondent appoints independent arbitrator Mr. Y, and the chairperson is Ms. Grace, also from Disputes Ltd. So there are two arbitrators from the same law firm. This does not say that there is any relation between that law firm and any of the counsel or any of the parties. Please don't mix things here. The only thing we know is the arbitrator and another arbitrator are lawyers in the same law firm. So I'd ask you now to reflect for a few seconds and then think if in your view this is something which could be problematic, if it's something which is no problem at all, or if it's a complete no-go. I'll leave you.
Harold, they can use the chat box to write their answers so we could see their
sure. I mean, we could do that. Maybe at least a few people could share their thoughts if they want to. That's a great suggestion.
Yeah, or we could have it like this sort of gaming stream, like Twitch, where you just press red or yellow or green, and then we could see like a sort of poll. So if you guys think that this is either a complete no-go, it's all right, but it's in the gray area, or it's a complete go, you could write in your answers in the chat box just for us to see what you guys think.
And I'll leave you for half a minute, and I'll quickly rush to get something to drink.
Okay,
while we encourage everyone to write down their answers.
Sure.
And keep in mind, there is no punishment if it's the wrong answer. Not at all.
Red. I see red. So it's a definite no-go. Now we see yellow. I see orange, yellow, red, yellow, yellow. Yellow again. Yellow again. You guys are very open-minded and very nice. I see a lot of yellows, and I see a green even.
Those who wrote yellow, you are wrong, because there is no yellow. There is only red, orange, and green. but I accept the yellow as an orange.
Oh, it's an orange. Oh, it's orange. I also just knew. I thought it was yellow.
No, it's orange. And ha 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 is not that's not a that's not an acceptable answer either. Okay, but I can tell you it's on the orange list. It's definitely not considered a complete no-go, but it's a situation which is not ideal, I should say. It's not ideal because when you are lawyers in the same law firm, of course, you can speak to each other, and there could be a risk that another arbitrator is left out. And that's not good. It depends what rules you're under, but usually the majority of arbitrators can decide. So even if the chairperson says, it should be B, if the other two arbitrators say it should be A, then those can overrule, so to say, the chairperson. So keep that in mind. However, same law firm is relative. If these days there are many international law firms in Indonesia. Imagine that one arbitrator is a lawyer in the Jakarta office. The other arbitrator is a lawyer in the Buenos Aires office in Argentina. That's definitely much less of an issue. Next situation. The arbitrator was a speaker, moderator, or organizer in one or more conferences, or participated in seminars or working parties of a professional, social, or charitable organization with another arbitrator or counsel to the parties. I'd again ask you to type your answers, and please write orange this time if you think it's orange. Don't write yellow.
Another yellow for the same reason. Okay. Orange, I guess. Yeah, orange. Anyone else want to have a go at this one? Green. Okay, green, green, green. So the green's coming. Red. Wow. Green.
Okay, it's first of all, it's great that so many of you are participating. I know that Indonesian students are not best known for participating, you know, among all the students around the world. So I'm very grateful. Those who wrote green, you are right. Keep in mind that what I'm doing here is a conference, arguably. And think about it. If this somehow hindered me in becoming an arbitrator because of a conflict, I would never do it. Or I should say, I would only do it if I were paid a lot of money to do this. And there are conferences in arbitration all the time. So people speak all the time. There are always some working groups on this or that. The IBA guidelines themselves were drafted by lawyers from around the world who first formed a working group. So this is definitely a green scenario. But, you know, please don't, I don't know, think something is wrong or it's bad if you get the wrong answer. This is really just to keep you awake and to make sure that you are engaged. Third situation, the arbitrator has a significant financial or personal interest in one of the parties or the outcome of the case. And I'll ask everyone once again to type their answers. And it seems a lot of people are writing already.
Oh yeah, red, 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 yes. Red, obviously, red for sure. Wow, such strong stuff. Red, 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 red.
Are you guys all sure? No, I don't want to confuse you. You're all absolutely right. It is red. It's as red as it can be. You have probably heard of the principle that no one shall be a judge in his or her own case. And if you have a significant financial or personal interest in one of the parties or the outcome of the case, then you are a judge in your own matter. Imagine a situation that, you know, how could there be a significant financial interest? Because it seems a bit random, but imagine that you are not just a member of the board, but you are a shareholder. And you know, you don't own 2 or 3 stocks, but you own 50% of the stocks, or make it just 10%. If it's 10%, then that's, you know, a lot of money. I can tell you in terms of financial interest, I was once involved in an arbitration against a company which is traded on the stock market. And this company won about 1.5 billion US. And we sent the award to the client after we received it, because the award would typically go to the law firm, not to the party directly. And they were, of course, very happy because they got $1.5 billion. And when you are traded on the stock market, then there are certain obligations. I'll not go into capital markets law now, but when there are important developments, you have to make an announcement, a formal announcement to the market. Because if not, then some people have information while others do not have that information, and that's unfair. So they made an announcement that they won the award, and the stock price went up exactly by around $1.5 billion. I mean, not the price of the share itself, of course, but the number of shares multiplied by the stock price led to an increase of exactly $1.5 billion. So this is a good example that how stock markets work. Okay, we move on to the third part of this lecture, myth and realities in international arbitration.
Sorry,
Myth
Harold, we
yes.
have a question with regards to challenge as well.
Yes.
Before we move into the myths. If an arbitrator was previously, this is from ADR, if an arbitrator was previously appointed as an arbitrator in a factually similar case to the one that he's currently arbitrating, does that give rise to a situation of justifiable doubt? Can the opposing party challenge his appointment as he has worked in a similar case before? Interesting question.
Again, it depends. If, you know, when you say the facts are similar, what does it mean when you say the facts? If, you know, I have done as counsel several arbitrations which were about gas price revision. So these contracts are usually for 25, 30 years, for a very long time. And eventually the gas price changes and one party wants a higher price and the other one wants a lower price. Ultimately, they all go to arbitration. Now, the facts are usually very similar because the gas prices work at least regionally on a continent basis. So you have the American, the European, and the Asian gas market, like at large. I'm really oversimplifying here, but at large, this is what it is. So, you know, the facts are the same. Does this give to rise if you sit in more than one gas price arbitration? Definitely not. When the same parties are involved, and especially when the same party appoints the same arbitrator more than once, then definitely this can be problematic. There is something in the Orange List which says the arbitrator has been appointed more than 3 times by the same party within, if I'm not mistaken, 5 years. So if one party keeps appointing the same arbitrator over and over again, then this gives rise to justifiable doubts as such. But if it just happens from time to time, then there is no issue with that. I think this was also a problem that occurred in the Bismuth a few years ago for those who were participating back then. I trust this answers the question, and I'll move on to myth and realities. Now, this is really something you do not learn at university. Again, I want to tell you, much of this is really my personal view. And just because it's my personal view, this does not mean that everyone else has the same experience. And I'd be very grateful for other experience if any of you has them. So the first myth, international arbitration is a highly sophisticated process. Reality, in my view, is a lot of people have no clue what they are doing. What do I mean by that? In arbitration, we often have very high amounts in dispute. The highest award ever issued was for $50 billion US. This is larger than the GDP of a lot of countries in the world. It's crazy amounts of money. The largest case that I have myself been involved in was over 22 billion US dollars. These are sums which we cannot really grasp mentally. These are just crazy amounts of money. And you would assume that because the stakes are so high, it's after all the arbitrator who is taking the role of the judge, that everyone involved is very sophisticated. In reality, this is often not true at all. And this applies both to counsel and to arbitrators. When I was acting as the Asian International Arbitration Center in Kuala Lumpur, I saw many different arbitrations in a short amount of time, because when you are at the institution, you see everything. And I can tell you that what I saw was sometimes disgraceful. And I'm very conscious of the term I'm using here. It was disgraceful. The arbitrators who acted and the counsel who acted often had no idea about the rules, the applicable rules. They had no idea about the law, and they generally didn't know how arbitration works. Some of them, of course. I'm not speaking about everyone, but I'm saying a lot of them. A lot of them had no clue. I would say my experience at the AISC, at least 20% made huge mistakes based on the rules. And the rules is something you really have to know about. If you don't know the rules, you should not arbitrate. That's my honest opinion, and it's a very strong opinion. I appreciate that, but it is my opinion. Both counsel and arbitrators usually get paid a lot of money, and because of that, both counsel and arbitrators should, at a very minimum, really know the rules very well. The reality is that very often they don't. I'm involved in a dispute right now. The amount is also well over 20 million now, not billion, but $1 million. And the tribunal doesn't fully know the ICC rules. And we had to do things which you would ordinarily not do, simply because these guys don't do their homework. So very often, despite these high amounts, the process is really not as sophisticated as it should be. That's sad, but it's a reality. Ilham, anything you would want to add, or any questions? Sorry, I didn't pay attention.
Yeah, I completely agree with you, and it's not just at the AIC. It's even in Indonesia. For example, at Bali proceedings that I have sat in, a lot of not the arbitrators, but mostly counsel don't have a clue of what they're doing. They don't know the Bali rules. They don't know, and what's even worse is sometimes that the substantive law even they don't master. So that's you get these like very silly questions of okay, you know what? Let's define this breach first before we get into actually the damages, you know. And sometimes the parties skip into that, and it is quite problematic in Indonesia as well. But yeah, I completely agree, and I don't think there are any questions on this topic. But I think what I wanted to share with you as well is that I had represented a client once, and the opposing party and my client had also agreed to appoint a presiding arbitrator in Bali. And everything was fine up until a few weeks before the proceedings. Bani told us that, and I am going on the record for this because I'm really not ashamed of this to say it out in front. Bani said, you know what? We're not going to let you appoint your arbitrator because our Secretary General should sit as the presiding arbitrator in these proceedings. And we had fought that so hard. We had challenged, we had brought it to court, but nothing succeeded. And at the end of the day, they still upheld the presiding arbitrator because they said that you are not allowed to deviate from the rules, which is contrary to the rules themselves, because the rules said you could deviate from the rules. So I completely agree with myth number one. It is not a highly sophisticated process.
That's, I think, the most outrageous story from the institutional side I've ever heard. But based on what I have seen myself and heard, I must say that I'm not too surprised.
Yeah.
Unfortunately.
Yeah.
It just shows that despite the high amounts of money involved, things don't always go perfectly well. Coming to the defense of arbitration here, and that's also important for you to keep in mind, it's not that litigation is always perfect. And we know that in some countries, judges will decide based on who will bribe them or who will pay more. And there are numerous other bad examples. So it's not that arbitration is all bad and litigation is all good, but that does not justify what's going wrong in arbitration. And something you shared or what I have shared also, it's simply something which must not happen. But unfortunately, it does. Myth number two, arbitration is always cheaper and faster. And this, of course, is faster than litigation. Reality is arbitration is very expensive and can often last for years. Now, again, I need to clarify this. Yes, on average, arbitration is going to be, on average, cheaper and faster than litigation. There is no appeal, and usually it's faster. But don't think that just because you go to arbitration, everything is going to be perfect. Right now, in several countries, they have introduced measures to do virtual court hearings. Now, virtual hearings are in principle also possible in arbitration, and they are used, but some rules make it easier to oppose against virtual hearings than other rules do. Whilst when you simply have a new law that's passed that says now virtual court hearings are possible, there is nothing you can do as a party. So COVID-19 is an example where there may be delays which were very unexpected and where courts can actually be faster than tribunals. But also keep in mind that arbitrations can be very complex, and just because of that, they can last forever. I mean, forever, I don't mean 15 years, but 6, 7, 8 years. This is highly unusual, but it still happens, especially in big disputes where the amount in dispute is very high. And, excuse me, especially when the arbitrators are very busy. And this is a trend, or it's not a trend, but a development that I'm very much criticizing. It's that there are some arbitrators who accept just any appointment they will get, and they believe it's okay if the parties have to wait for an award for well over a year from the moment the proceedings were closed. So we are at the end of the proceedings. They close the proceedings, no party can submit anymore, and even then it takes them over a year. They think that's okay. In my view, this is not okay, and nothing can justify that it takes so long, because if you really dedicated your time and resources to this award, you could definitely finish it in a matter of a few months. Not 1 month, not 2 months, but make it between 4 to 6 months if there are 3 members of the tribunal. It's definitely something that's possible. And if arbitrators were more conscious of their own time, it would be better. Also, it can be a very, or I should say it usually is a very costly proceeding. Now, again, this must be seen in perspective. When you have a very complex dispute in court litigation, it's not going to be done in 2 months or 6 months. Also in court, it will take a very long time. And when it comes to the cost, the main costs in an arbitration are the costs of your party representative, of counsel. So whether you go to litigation or to arbitration, it will not really make much of a difference. But still, there is this myth out there that when you go to arbitration, it's always fast, it's always cheap, it's always wonderful. And this is a myth I want to highlight, is a myth. And reality can be different. Again, do not see it, please, as me saying litigation is good, arbitration is bad. That's definitely not what I'm saying. I just want you to be open-minded here and understand that there is more. Ilham.
Right. Harold, I think you have just about 2 to 3 minutes left to wrap up before we have a question and answer session. I think you could just proceed with your slides.
Okay. Then that's the last myth then I'll share. I actually had 2 more slides, but that's totally fine. We say arbitration is as good as the arbitrator, and that's why we appoint the best suited arbitrator. In reality, the appointment process is not sophisticated at all. I'm again using this term. Many parties go for who is the most senior person available. They go for the oldest person. And this may well be the best choice, but very often this person which is appointed has nothing, no quality except for age. And age and experience is very, very important, but it doesn't automatically make you a good arbitrator. That's simply the wrong approach. Again, please see this in the proper relation. Just because you're old, it doesn't make you a good arbitrator. Yes, that also means just because you're young, it doesn't make you a good arbitrator. Also, it means just because you're old, it's wrong to say it makes you a bad arbitrator. It really depends. What I'm criticizing here is that when there is so much money involved, you would assume that the lawyers who get paid, hundreds of thousands of dollars would really sit down and think very, very thoroughly and carefully as to who the person of their choice should be. My experience from working with and against some of the largest firms in the world is that the time that's spent on selecting an arbitrator is usually not very much. It should be much, much more, and the whole process should be more sophisticated, should be more detailed, more structured. With that, I thank everyone, every one of you in front of your screens for your attention, and I look forward to getting more questions. Unless, of course, sorry, Ilham, you want to add something right away.
No, I completely agree with you. And I think we have our first question for this Q&A session. It's from Diva from Universitas Gadjah Mada. She's asking, I've read arguments that said arbitrators tend to simply compromise somewhere in the middle of what is demanded by the opposing parties when rendering arbitral awards. Well, yeah, I've heard that as well. To your experience, is it really a reality or a myth?
The splitting the baby in half, as we call it, compromise somewhere in the middle is a nice term. In arbitration, we usually say splitting the baby in half. I've seen it before, yes. I believe some arbitrators have this wrong perception that it's unfair if they decide completely against one party. In my view, this view is complete nonsense, because very often, once you determine who is right and who is wrong, so to say, there is no 80, 90%, it's 100% versus 0%, or 0% versus 100%. So from my experience, this is the wrong approach. And I've seen it, yes, but I'm strongly against it. But sorry, one last comment. Although I've seen it, I haven't seen it very often. I've seen it a few times, maybe in 5% of all arbitrations in which I've been involved.
Yeah, I think this is also an issue in Indonesia. I mean, it's not just arbitration. I've seen litigation or decrees or decisions by courts which have split the baby in half. So I think in Indonesia it's very prominent, but in arbitration, considering you're paying for it, you're paying for justice.
Right.
It's a very lazy way of an arbitrator to say, you know what, let's just split it in half without looking at the merit.
Right.
Here's another question here. In this pandemic situation, transnational business contracts tend to have disputes. How does ADR consider to enforce the UNIDROIT principles, and how important is it to incorporate these principles in transnational business contracts?
Okay. I hope this doesn't frustrate anyone, especially those who take the Wismut. I have never seen any contract which spoke about UNIDROIT. I've never seen it, and I've seen quite a few contracts. Trust me, I didn't count them, but I have a lot of white hair, so I've definitely seen a few hundred contracts. Yeah, what should I say? Also, please keep in mind that ADR as such, be it arbitration or any other process, in principle, it has nothing to do with UNIDROIT. UNIDROIT is about the substantive law. And if you want to agree on UNIDROIT, you can do so in your national or international litigation as much as you can do in arbitration. It's not connected. The reason we see it so much in the Wismut is that, as the name says, UNIDROIT, unified law, so to say, it's the same for everyone who sees it, and no one is disadvantaged.
Yeah, I totally agree.
Yeah.
I've also never seen a contract where it said that the governing law are the UNIDROIT principles. I think that's just for the fact that they are principles in itself. They're not a substantive law. A lot of things don't go into the UNIDROIT principles as opposed, for example, to the counterpart, the CISG. And I think that whenever I do see a contract where there are hints to the UNIDROIT principles, I think they are always subsidized, I would say, or they are supplemented by a standing substantive law, and which is in most cases English law.
I mean, you could in theory say where the CISG has its gaps, you refer to UNIDROIT, but in principle, I mean, in my view, it's the better approach to refer to national law. But again, this is something which you would do in the course of the arbitration. It's not the contract itself.
Yeah. There is another question from under the new US-Mexico-Canada agreement. There are very limited circumstances for arbitration, and the US litigation market is larger than the arbitration market. Do you believe that there is a trend in the US to prefer litigation over arbitration?
Okay, that's a very specific question. I think the person who is asking is referring to the free trade agreement between what used to be NAFTA and was now replaced. I'm not an expert on the U.S. Disputes market, but litigation is everywhere a bigger market than arbitration is. Keep in mind that arbitration is predominantly used only for cross-border disputes. It's usually not used so much for national disputes. I don't know any numbers, but what I can say on the US is that arbitration is definitely used a lot more than in other countries, simply because they allow a lot more to be done by arbitration than what other countries do. For instance, and most importantly, in the US, consumer disputes can go to arbitration, which in many, if not most countries, they cannot. And there are even class actions, consumer class actions done by arbitration in the US, which simply doesn't exist in many other countries. So again, I don't know any statistics. I'm not an expert, but I would assume that the situation in the US, if we compare the domestic litigation market with the domestic arbitration market, is that relatively speaking, the arbitration market is bigger than it is in other countries. But again, and that's maybe something I didn't mention and want you to be aware of. I have, most of my professional life, I have done international arbitration, and I've seen it in various different roles, as counsel, as tribunal secretary, as in-house counsel, as arbitrator, as an academic, so to say. I believe it's a wonderful process, but it doesn't make it a perfect process. And above all, it doesn't make it a process that's perfectly suited all the times. People say that democracy is the best of all bad processes, or all bad forms of government we know, or the least bad, so to say. And I think we can say the same about arbitration in many ways. Ideally, there is no dispute. Ideally, the dispute is resolved by means of mediation or even negotiation. That would be much better. I mean, not for the lawyers, but for the parties, for the economy overall. But it is what it is. There are often disputes, and they need to be resolved. And when it's a cross-border dispute, on average, arbitration is much better than litigation is.
Yeah, I completely agree. But I think for the U.S., when we're talking about the U.S. market, Andrew, you might want to look it up. There has been this research by the Queen Mary University of Law, which ranks different arbitral institutions. I think this was done in 2015 in collaboration with Herbert Smith Freehills and Hogan Lovells. There tends to be a bigger arbitration stimulus in Europe as well as in Asia, especially in Singapore and in Hong Kong. But when I did my research on arbitral institutions, I don't think there were that much emphasis on arbitration in the US itself, like commercially. There's another question from Jovanka. Other than delays, what other concerns do you have in regards of conducting virtual arbitration hearings?
Okay, first of all, virtual hearings would not result in a delay. Because when you cannot meet now, then meeting virtually is in fact much better, because no one needs to travel. The concerns I have are security. There was a case, this has nothing to do with arbitration, this is just virtual hearings. There was a case in the UK recently, just end of July, where a Zoom link was shared. I'm not entirely sure if it was accidentally or intentionally, but something which was supposed to be private suddenly became public. A big concern I would have about virtual hearings is, can you fully see the witness? Is there anyone in the room who will coach the witness, who will tell the witness what to say? Those issues. And generally, security concerns. You know, how can you ensure that there's no one else on the call? How can you also ensure, you know, think about this event. The organizers ask everyone to turn off the cameras. And this is also because the connection is unstable in Indonesia. If I'm involved in a virtual hearing and I'm doing this from KL, from Kuala Lumpur, where I'm now, on average, I am in a better position, so to say, technically, than someone is from Jakarta. Because on average, the internet connection in KL is better than the internet connection is in Jakarta. Now, as long as the internet connection is good enough, that should be okay, but can we guarantee that it's good enough? If there is one party that is not properly seen on the screen while pleading, because, you know, there's always, you know, you suddenly see the party like this and nothing moves, then it's definitely not ideal. And that puts that party in a disadvantageous position in comparison to the party from KL or, you know, wherever, where the internet connection is better. And of course, I'm just using Jakarta as an example, since many here are from Indonesia, if not everyone. We could say the same about other parts of the world. If you are from the countryside and not a city, on average, your internet connection is going to be worse. And it's unfair if you have a disadvantage because of that. So these are other concerns I have with virtual hearings.
Yeah. Another problem, I think, with virtual hearings in Indonesia is that we don't have the regulatory framework to actually conduct it. You know, there are words in the Indonesian arbitration law where it says for the Indonesians, di hadapan, in front of the tribunal. How are we, like an Indonesian judge would automatically say, you know what, you gotta face the arbitrator. And I'm not gonna say which institution, but in Indonesia there has been a problem with this. It has administered this arbitration virtually, and then they ran into enforcement problems. So I guess for Indonesia, it's better to hold off for now, even though some institutions offer it, especially if you're seeking enforcement in Indonesia.
Right. The ICC rules also say in person. The tribunal shall hear the parties together in person. Now, the ICC itself claims that this does not mean in front of the person, really. But I have a very different view. I think it's clear from the structure of the ICC rules and from the drafting history that they clearly differentiate between regular hearings on the one hand, which are supposed to be together in person, and everything else.
Yeah. I think the organizers are telling me to cut it, but I think we can squeeze in one more question and then I'm going to conclude. What trends do you see for the Indonesian legal market? Will more Indonesian parties choose international arbitration over litigation?
Eventually, yes, because Indonesia needs foreign direct investment. And I read statistics once that in the last years, FDI, foreign direct investment, accounted for about 10% of Indonesia's GDP. If that trend continues and if there are more liberalizations, we will see more and more FDI and thus more and more international contracts. And maybe the Indonesian parties are not so keen on choosing the international arbitration, but the foreign parties are. So ultimately, yes, I clearly see that there will be more international arbitrations in the future, especially less BANI and more international institutions.
Yeah, I hope so as well, actually. And you know, of course, I mean, this question would a lot depend on like every person who is at their computer right now. If you advise your clients, if you can convince your clients in such a way to choose international arbitration over litigation, then of course the market for arbitration is going to increase. And I see the organizer is messaging me. All right, I'm just going to conclude, Harold, if that's okay with you.
Of course.
So thank you again, Harold, for this wonderful session. We have learned about some of the concepts in arbitration, separability, challenging an arbitrator, writing an arbitration agreement, some of the things which I don't think are offered in depth unless you join a moot at Indonesian universities. We have also taken a look at what would constitute as an impartiality or independence of an arbitrator. And if you are more curious about that, you could actually look up the standard under the IBA rules or the Uncitron model law, and also look at the Indonesian arbitration law and how we address impartiality and independence. Just as a hint, it's not that well addressed. Also, Harold has talked about the myths and the realities of arbitration, which is sometimes in Indonesia, I would say, very oversold to clients that arbitration is going to be this and that. But I think Harold has actually hit the nail on its head when we challenge these very conservative concepts of what arbitration should ideally look like. And I would like to thank everybody for participating in this seminar, in this webinar. Of course, I learned a lot as well from Harold from this talk. And I think this is for me as well to say out for the participants. By participating in this webinar, attendees are eligible for annual BIAMC student membership at a special promotional rate of USD 24 or 360,000 rupiah. And this offer is only available until the end of today. I think this is in the chat box if you guys are interested. And I think now it's my time. My time is over, and I'm going to give it back to Farah.
Can I just also, Farah, before you say something, also thank everyone once again for joining. You, Ilham, for the great discussion, which went far beyond the usual moderation, for which I'm very grateful. Especially what I truly liked is that you managed to connect what I was saying to Indonesia. And you obviously know a zillion times more about Indonesia than I do. So I think with you explaining the status in Indonesia, it was very useful to connect sort of the international perspective back to Indonesia. So I'm very grateful for that, and thank you. And once again, thank you all to the organizers, or co-organizers, I should say, and everyone who participated. Thank you.
Thank you so much, Dr. Sippel, and as well as to Ilham. If I could direct the participants to turn on their videos at this moment so we could take a commemorative photo together.
Commemorative.
Yes, I think we're just waiting for everyone to turn their videos on.
Someone is asking if the host can turn on the camera.
Yes, can the other
But-
committees try and... Okay, well, thank you, everyone. I think the committee members are currently taking a picture of this. Justin, is everything okay?
So we have three.
I understand
for
some
that.
of...
So the first 3 pages, we have attendants placing their camera on, but for the last 2 pages, I think that there are still some participants who have yet to turn on their camera. So I think we can wrap it up over there, and I'll hand it back to you, Farah.
Okay, that's great. So just some closing remarks for me. Initially, I would just like to thank everyone for their cooperation in this photo taking session. And as we approach the end of this event, on behalf of ILMS FHAUI, I'd like to extend our deepest gratitude towards Dr. Harold Sipple for participating in today's webinar, as well as to Ilham for being a moderator today and providing insights on alternative dispute resolution, as well as arbitration. So I'd also like to thank all the participants for attending today's webinar, and I hope that all of you have learned a great deal on ADR throughout this enriching session, as I know I have as well. So just to reiterate what Ilham mentioned previously, if any of the participants are interested in the world of ADR, the BIAMC offers a student membership which caters to this interest. So benefits here include access to online learning platforms, free e-certificates for modules on ADR and career development, as well as the chance to become a student ambassador for your own university. So the link has already been sent in the chat. And all attendees of this webinar are eligible for a special discounted rate at $24 US, as well as 360,000 IDR. So again, please find the link in the Zoom chat box. And additionally, I would just have 2 points of information towards the participants. So firstly, we'd just like to inform you that participants are eligible for e-certificates, and this will be sent within the following week to your respective email addresses. Secondly, we also look forward to seeing you in any future installments of the ILMS webinar series. Our next webinar series is on the theme of building a career in ADR, again with Dr. Harald Sippel. And I'd just like to thank everyone for their cooperation in today's webinar. And I hope that this webinar has been fruitful and has been a good learning experience for us all. So I think with that, participants are free to leave. Thank you very much. And we look forward to seeing everyone in any future events.
Harold, nochmals vielen, vielen Dank. Ne? Es war sehr informativ. Thank you so much again.
Thank you from my side. Vielen Dank. The pleasure was mine, and I meant everything I said. I also learned about Indonesia. I did go through the arbitration law once, but only once. So of course you don't remember everything.
Yeah.
Yeah.
We were actually in the process of drafting an amendment. So there are a few like consortiums who are actually wanting to make this amendment, but it has never made the House floor yet.
Right. That's what Prof. Supancana told me.
Yeah, because in
Yeah.
Indonesia you sort of need this. It's called naskah akademis, so the universities need to have this. The universities need to back the law, and there has been no prominent university in taking the initiative to